the Supreme Court's, idea of what the Constitution is supposed to do in the A.K. Gopalan judgment, you will realize that our Constitution, when we began interpreting the Constitution in 1950, we did not begin this interpretation very generously. We were very conservative, right? So in that sense, I think we have never really, whereas the Constitution is supposed to be a liberal, is supposed to be founded on the principles of liberalism and democracy, which was not really embodied in the Supreme Court's verdict in the A.K. Gopalan versus State of Madras case. So we did not begin an ideal footing, and throughout history, there have been times when the interpretation of the Constitution has left a lot to be desired in terms of meeting the ideals of liberalism that is embodied in it, right? So as far as our Constitution being a nominal one is concerned, right, there is you can see that a lot of these provisions, for example, you have the right to the freedom of speech and expression under Article 19, or the right to life and personal liberty under Article 21. For a vast majority of our population, for a vast majority of our citizens, these are rights that only remain on paper. We have not been really able to create the socio-economic conditions for these rights to be given proper effect, right? And it is not, and it's not, at various points of time, we might have, some judgments might have done a little socio-economic justice, but at most of the points of time, we have resembled what might be called a nominal constitution, and then coming to a semantic constitution, right? At the outset, when the constitution was first drafted, there appeared to be no no apparent weaknesses in limiting governmental power. But Indira Gandhi's regime exposed a lot of these weaknesses, right? And it was not just with respect to rights and liberties that these weaknesses were exposed, but it was also with respect to the working relationship between the center and the state. So in that sense, at one point of time in our history, our constitution has resembled a semantic constitution as well, right? So we can see that given these three classifications, normative, nominal, semantic, you can only attribute, you can only with certainty say that we haven't been a normative constitution, but on and off we have been a semantic and a nominal constitution, right? So the complexity of categorization is already visible to you, right? So the descriptions of our constitution that are popularized when we read textbooks are not the only descriptions that we actually need to speak of, right? And this is not just it. There are liberal democratic constitutions, there are liberal non-democratic constitutions, right?
Sir, we can't hear you. Aishwarya? Aishwarya?
Yes, ma'am.
I think the speakers left the meeting, right?
Yes, I don't seem to see him.
Okay, I'll just get back.
Ha.
The speaker will be with us shortly. He just got disconnected. Oh, he's here. Thank you. Yeah, we can't hear you. Mute. Yeah.
Yeah, so where was I? So liberal democratic constitutions, it is a constitution in which the government is run by elected officials, and the limitations imposed on these government are in the form of individual liberties, right? So which is what our constitution is. It's a liberal democratic constitution. And then you have a liberal non-democratic constitution in which the constitution does not establish a government. The constitution only modifies the powers, one modifies the form of a government. For instance, you could have rights for individuals in the monarchy, right? That's a liberal non-democratic constitution. And then you have non-liberal democratic constitutions in which the elected officials the elected officials run the government, but there are no proper limitations on their governmental power, right? So if you have fundamental rights on which, if you have fundamental rights on which there are a lot of restrictions, right, enumerated within the constitution itself, then you will have a democratic non-liberal constitution, right? Because the rights cannot be effectively utilized to give effect to constitutionalism or to place limitations on the government. Then there is the social or the welfare state constitution also. Now, the key difference between the liberal democratic constitution and welfare state constitution is that there are different kinds of values that are prioritized, right? On the one hand, in the liberal democratic constitution, you have individual liberty that is prioritized. And then in the welfare state constitution, it is equality that is prioritized, right? And these two values, the value of liberty and the value of equality, might compete with each other, right? So if you have, say, a section of the society which is backward, which is in need of affirmative action, right? Then the individual liberty of those that are privileged might have to be compromised. So this is the difference between a liberal democratic constitution and a welfare state constitution, right? So again, when we describe our constitution, when we try to categorize a constitution, it is not, except for the fact that our constitution, the only thing that's been very constant about our constitution, about the way that our constitution has been given effect to, not the constitution itself, is that we have been democratic, right? But as far as liberalism is concerned, as far as meeting the requirements of a welfare state are concerned, right? As far as meeting the needs of liberty and equality are concerned, we cannot with a lot of certainty say, and we are going to examine Supreme Court judgments in this regard, we cannot with certainty say that these principles have been given effective properly, right, by the judiciary. Now, so these are very broadly the forms of the Constitution. Now, what I'm going to do is to outline the scheme of the Constitution, right? So the Constitution creates our state, and then it creates, it defines what the state is, and then it imposes limitations on the state in the form of fundamental rights, right? So there are a number of fundamental rights, and the definition of a state itself is quite expansive, right? It also includes governmental bodies, which are sponsored by the state. It has governmental bodies which are even feebly associated. Any body which is even feebly associated with the government can meet the test of state as described in the Constitution. And the significance of any body being described as a state under the Constitution is that fundamental rights can be enforced against that body, right? So this is a very important facet of our Constitution for you to know, that when we speak, and this is a mistake that I've seen happen very often in popular culture, that when we speak of fundamental rights being enforced, say for instance, when we speak of our right to life being enforced, or our right to freedom of speech being enforced, we speak in popular culture of these rights being enforced against private entities too, right? Whereas it is very debatable whether fundamental rights can actually be enforced against private entities. We can with certainty say that they can be enforced against government entities, right? So for the fundamental right to take effect, for you to have recourse, for you to have remedy, you will need to first prove that the body which has acted against you is a state in the first place. And there are a number of ways in which the Constitution permits us to categorize a certain body as a state, right? Now, we are not going to get into those categorizations in detail. So you have the fundamental rights, you have the most salient fundamental rights, you have the right to equality in Article 14. You have the various freedoms under Article 19, right? The most salient of which is the right to free speech and expression. And then you have the right to life and personal liberty under Article 21. And along with these, you have a number of other rights as well. You have the right to freedom of religion and so on and so forth, right? And then after all of these rights have been enumerated, you also have the remedies for these rights, right? Now, for our Constitution to work efficiently, you need a separate body that enforces the principles. So the Supreme Court, our Constitution creates the Supreme Court and creates the jurisdiction of the Supreme Court, right? So the remedy that is available and the jurisdiction under which fundamental rights can be enforced, the provision under which fundamental rights can be enforced, the remedy is provided following these fundamental rights in Article 32, right? So Article 32 is not, under Article 32, you can approach the Supreme Court if your fundamental rights are violated. And under Article 226, you can approach the High Court if your fundamental rights as well as any other legal or constitutional rights are violated, right? So this is the scheme with which the Constitution operates, right? And all of these provisions that I have just mentioned, they concern the relationship of the government to the individual, the relationship of the state to the individual. Now, what the Constitution also does is it regulates the relationship not just between the individual and the state, but also between the different branches of the government, the legislature, the executive, and the judiciary, and also between the center and the state, right? Now, there is, just like you have, just like there is a possibility of abuse of power by the government vis-a-vis an individual, there is also a possibility of abuse by one government against the other in the interrelationship between them. So when you have the executive, the legislature, and the judiciary, right? All of these branches are separated in our Constitution. Each has a very distinct and definite sphere, has their own function, and an overlap is rarely permitted, right? There is a system of checks and balances. So you have just like you have fundamental rights which safeguard individual liberty and dignity, you have the doctrine of separation of powers which safeguard the different branches of government from abuse against each other, right? So there are different kinds of separation of powers. There's vertical separation of powers, which is the separation of powers between the center and the state, with both the center and the state having very defined functions and one not interfering with the other. And then you have the horizontal separation of powers, which is the separation of powers between the three branches of the government which are considered to be equal. That is the legislature, the executive, and the judiciary. This very, very broadly is the scheme or the outline of the constitution, right? So what we have now figured out is what kind of constitutions exist. The question that we have sought to answer is whether it is possible for us to attach any one label to our constitution, or whether our constitution moves between categories. And then we have also seen we have also figured out the scheme of the constitution, right? Now I'm going to walk you through some of the provisions of the constitution and what the Supreme Court has done. So when we speak of 70 years of the constitution, we are essentially speaking of how the constitution has been interpreted by the Supreme Court in all these years. And I have singled out a few landmark judgments for you to understand how this interpretation works, right? So we'll start with the earliest and most notable constitutional case, which is A.K. Gopalan versus State of Madras, and this ties back to one of the themes that I pointed out earlier, in the sense that it is my opinion that in the first 25 years, our constitution was very conservatively interpreted. Conservative, not in the philosophical sense, but conservative in the sense that the text of the constitution was not expanded in its meaning. I'm not speaking about philosophical conservatism here. I'm speaking about textual conservatism, in the sense that when the constitution was created, okay, certain provisions came into existence and certain words were used with very specific meanings in each of these provisions. What was happening in the first 25 years was that these words were being given very limited meanings, in the sense that these words were understood only in the sense that the framers of the constitution wanted them to be understood. Okay, that's a very limited way of looking at the constitution. Okay, it's called a literal interpretation of the constitution. You're interpreting the text as it is. You're not looking to creatively understand what each provision says, right? An example of this, and A.K. Gopalan versus State of Madras is a classic example of literal interpretation, in the sense that the question before the court, without going too much into factual detail, was so you have Article 14, which is the right to equality. Article 19, you have a number of freedoms, right? For instance, you have the freedom of movement, you have the right to free speech, and then you have Article 29, the right to life and personal liberty. Now, Article 21 provides that your right to life and personal liberty cannot be deprived. And please listen to me very carefully here. Your right to life and personal liberty cannot be deprived except according to procedure established by law, right? You look at the language that has been used in Article 21. No person shall be deprived of his right to life or personal liberty except according to procedure established by law. Now, the question before the court, right, and there was a very creative argument made in this case, was that there are a number of liberties enumerated in Article 19, okay? And Article 21 deals with your right to life and personal liberty. The contention that was made before the court, the argument that was made before the court, was that Article 19 and Article 21 are related to each other, right? That the liberty in Article 19, that the liberty is enumerated and the freedoms enumerated in Article 19 are also are similar in characteristic, are contained within the expression right to life and personal liberty, within the expression personal liberty under Article 21. So what does this effectively mean? When you claim that two rights are linked, when you claim that a number of liberties in Article 19, say for instance, you have the freedom of movement, right? Or you have the freedom of speech, and then you have the right to personal liberty under Article 21. When you claim that both of these rights are linked to each other, what practical consequence does this have? The consequence is that when a law is examined, when you try to figure out whether a law is constitutional or not, what you do is you figure out if the law has violated any fundamental rights. Okay, so when examining the constitutionality, usually you claim that any one fundamental right is infringed, but when you claim that two fundamental rights are interlinked, right? What the threshold that the law must meet is that the tests for both the rights must be satisfied in order for the law to be constitutional. Are you able to comprehend what's happening here? The argument that was made before the court? Is there a doubt?
I think, can you repeat it again?
Yes.
Just one time. Yeah.
So there is, So there is a law. See, look, there is take any statute, take any ordinary law, any ordinary statute. For that law to be legitimate, to be valid, it must be constitutional. That is, it must not violate any constitutional principles, right? And when you examine the constitutionality of a law, you're examining the constitutionality of a law with respect to the fundamental rights that have been enumerated in the Constitution, right? I have outlined earlier the most significant fundamental rights, the most salient fundamental rights. Article 14, the right to equality. Article 19, the various freedoms. And Article 21, the right to life and personal liberty, right? So when you claim, when a citizen goes to court and claims that a law is unconstitutional, what the petition of the citizen is effectively claiming is that the law violates one of these rights. Okay, it is usually the violation of one right that can be claimed, right? You either claim you claim that the law violates your right to equality under Article 14, or you claim that the law violates one of the freedoms under Article 19, your freedom of movement or freedom of speech and expression, or you claim that the law violates your right to life and personal liberty under Article 21, right? You're attacking the law on the basis of any one right. But the argument that was put forward in A.K. Gopalan versus State of Madras was that all of these rights are connected to each other. So if any one right is violated, so for instance, if Article 19 is violated, it must necessarily mean that Article 21 is also violated. So if your freedom of movement under Article 19 is violated, it would necessarily mean that your right to personal liberty under Article 21 is also violated. Okay? This was the sort of creative interpretation that was sought for the Constitution by lawyers in the early years, and this was in 1950, A.K. Gopalan versus State of Madras. But the court claimed that this argument does not hold water, that each of these fundamental rights, they are not connected to each other. Okay, that if one fundamental right is violated, it is only the test for that one right that must be satisfied alone. The violation of any other fundamental right within Part 3 does not follow, right? So what the court was effectively telling us, okay, through its ruling in A.K. Gopalan versus State of Madras, was that when you have a number of provisions in the Constitution, we are only going to look at these provisions in isolation. We are not going to look at the rest of the Constitution. We are not going to see the Constitution as a whole document, and we are not going to see these fundamental rights as the different limbs of the same body. Okay, we are going to see them as separate entities, right? Which is a very, very textually conservative way, a very limited way of looking at the Constitution, which was what was essentially happening for the first 25 years. And of course, then what had happened after that was that Indira Gandhi took over, and she imposed the emergency. She sought to meddle with the Constitution. She sought to amend the Constitution to her will. And the emergency, she tried to change the nature of the Constitution itself through the amendments, right? And the imposition of the emergency also led to widespread human rights violations. It also exposed to us the fact that our part 3, which enumerates all the fundamental rights, is not, as it stood back then, was not a very sufficient tool for us to ensure that our freedoms and liberties were intact. That, the Constitution was so inherently weak that the goals of the constitution that the framers had in mind could not have been met, right? So there are two ways that this weakness was addressed. Very, very broadly speaking, there are two ways. The one was in the Keshananda Bharati judgment, right? In the Keshananda Bharati case, the court held that it is not possible for any government to amend the constitution to the extent that the fundamental nature of the constitution itself changes, right? And part three of the constitution, which enumerates the fundamental rights, it's a very sacrosanct part of the constitution. It's a part of the basic structure. So our rights and liberties forming a part of the basic structure, the nature of our rights and liberties cannot be altered through constitutional amendments like the way that Indira Gandhi tried to do. And the other was the Supreme Court our judiciary had taken a very severe beating during Indira Gandhi's time, because the judges, for instance, in ADN Jabalpur versus Shivakant Shukla, which is known as the habeas corpus case, the court, lost its sort of moral compass, ruled in favor of Indira Gandhi. And Indira Gandhi also during this time packed the court with judges who were of a favorable disposition.
The guest lecturer will be joining us shortly. There have been too many technical glitches, and I apologize for the same. Until Sir comes back, since it's our, Constitution Day, how about all of us quizzing? Let's have a quiz on Indian Constitution, because, he's back. We could continue it later. Thank you. Sir, please unmute yourself.
Yeah. So the reason I mentioned the emergency years and the way that the judiciary capitulated to Indira Gandhi's abuses of power is because it's the prelude to what we popularly know as judicial activism, which continues to this day. Now, the reason that our court became a very tried to reinvent itself as an activist court in the 1980s was because of the experience of the emergency and the institutional humiliation that it had experienced during Indira Gandhi's regime. Now, there are two ways it did this. I'm going to very quickly walk you through those. The one is through the Maneka Gandhi judgment, in a very broad and notable sense, right? There are a lot of other judgments that were written, but I'm only touching upon this judgment now. And then there is also the instrument of the device of public interest litigation, right? Now, what was done in the Maneka Gandhi case was that the right to life, prior to this, we have discussed the A.K. Gopalan case, and we have understood how the constitution was narrowly interpreted. What the court tried to do in the Maneka Gandhi case was to interpret the constitution as liberally as possible. In the sense, give it as wide a meaning and as expansive in a meaning as possible, right? So the right to life, Article 21 claims that the right to life, you cannot be deprived of your right to life except according to procedure established by law. The ruling in Maneka Gandhi was this procedure established by law must be not a procedure which is prescribed. It is a procedure which is established. A procedure which is established is not simply one which is written. It is also fair, just, and reasonable. Okay. So when a law tries to take away your life, your right to life, it is not enough for that law to be codified. The law must also be fair, just, and reasonable. So when you speak of a law being fair, just, and reasonable, it would also mean that the law has to meet the requirements of equality under Article 14, right? And the end result of the Maneka Gandhi judgment was that all the fundamental rights, all the most salient fundamental rights, Article 14, that is the right to equality, Article 19, that is the various freedoms, and Article 21, that is the right to life, all of these were read together, cumulatively, right? So if you were to claim that the law is unconstitutional, and if you were to make a claim that any one right is violated, it would necessarily mean that the other rights would also be violated. So if you're claiming that Article 21 is violated, it would also mean that Article 19 stands violated by the same law, right? So the court tried to change, the court tried to depart from, in the post-emergency years, the court tried to depart from the meaning, from the textual meaning that was ascribed to the Constitution by its framers, and this was done with the intention to more effectively safeguard our rights and liberties, right? So the expansive interpretation was, in a sense, the emergency forced the judiciary's hand to do this. And the reason I'm mentioning in this judgment is because it has very important consequences to this day, right? Now, there is the PIL as well. The public interest litigation is a device using which any grievance which it is felt is of public importance can be addressed by any citizen by approaching the court, by directly approaching the Supreme Court. Now, when we speak of PILs, we have in mind, say, for instance, when there is a problem with our public civic infrastructure, we can get these redressed by approaching the Supreme. We can just write a letter to the Supreme Court, and they might address this, right? If there is a merit in your case. So this was another way in which this was another device using which the court tried to reinvent itself in the post-emergency years. But the problem with the use of the PIL and with the popular perception of the Constitution is that the PIL has not, in fact, been very effective at favoring the public, right? The device of public interest litigation over the years has been used against the socio-economically weaker sections of the society, right? We'll come to that later if we have time. I'll quickly move on to the most recent salient judgment, which I think deserves to be discussed. So when we speak of the right to life and liberty, when we speak of an expansive interpretation of the right to life and personal liberty, the one judgment that must immediately come to our minds is the Nate Johar judgment, right? It is the judgment that decriminalized homosexuality in India, right? So there are two very significant aspects of this judgment. One is that it applied the expansive interpretation of the right to life and personal liberty that was that was first held by the court in Maneka Gandhi versus Union of India, right? So the right to life now included a number of other rights as well, and apart from just giving an expansive interpretation to Article 21, it also very notably brought into the public imagination the concept of constitutional morality. Now, when we speak of concepts like liberty, equality, right? When we speak of the right to free speech and expression, when we speak of the right to religious, when we speak of religious freedoms, when we speak of the right to equality and the right to life, all of these collectively form a certain kind of morality. And this morality by the Supreme Court has been identified as constitutional morality. Now, what the court has done in the Navtej Singh Johar judgment is that it has tried to describe the basis of discrimination against homosexuals in India, right? So so essentially the ruling claims that homosexuals are discriminated because the kind of their sexuality does not conform to the majoritarian morality that we have in our country, to what is understood in the popular imagination to be Indian culture, right? So this kind of majoritarian cultural morality is not, according to the Supreme Court, the kind of morality that the Constitution espouses. The Constitution espouses the morality flowing out of the rights of equality, right? Out of the right to equality, the right to life and personal liberty, and the freedom of speech and expression, right? And each of these rights, when homosexuality is criminalized, when homosexuality was criminalized under Section 377 of the IPC, each of these rights stood violated. Article 14 stood violated because there was no reasonable classification that was made under Section 377 of the IPC. Now, what is a reasonable classification? It is a classification that is comprehensible, that has the basis on which the law differentiates between two groups of people under Article 14 must be comprehensible, must have some sort of logics. So when you're and this basis of difference, that is the intelligible differentia, the difference that can be comprehended, must have a connection to the object of the law, right? Now, the object of Section 377 was to essentially protect women and children. And the court held that the basis, that the distinction between homosexuals and non-homosexuals and heterosexuals did not actually meet this object. For this reason, discriminating against homosexuals, against the LGBT community was arbitrary and fell foul of Article 14, right? Then you have Article 21 that was also violated, in the sense that inherent in the right to life and personal liberty is also the concept of dignity, right? And since one's sexuality is a very core part of who one is, since it's a very inherent trait of a person, since it's the most, since it is a trait that is the most natural, right? That's present from birth. If that is stigmatized, if sexuality is stigmatized, it would mean that the dignity, individual dignity is taken away. And if dignity is taken away, the right to life and personal liberty would stand violated, right? And the expression of sexuality, when you criminalize homosexuality, you are also criminalizing not just the act, but also the expression of a certain kind of sexuality, right? And when you criminalize the expression of a certain kind of sexuality, it would mean that you're criminalizing, that you're taking away the right to free speech and expression. And for this reason, Article 19 also stands violated, right? So you can see that in Navtej Johar, what was happening was that each of these rights, Article 14, 19, and 21 were violated individually, and applying Maneka Gandhi's test, that is, if one right is violated, it necessarily follows that the others are. All the three together were as a whole violated. And for this reason, constitutional morality, Section 377 does not adhere to constitutional morality. It might be in adherence to popular majoritarian morality, but not constitutional morality, was the court's verdict. Now, the problem with this articulation of constitutional morality is that when you speak of law and morality, it is always very vague, right? Say, for instance, when you have provisions like Article 14, Article 19, and Article 21, you're working with something that's very concrete, okay? But it's still very difficult, even in legal terms, to actually define morality, right? So when you define it in philosophical terms, it still feels reading the judgment, you feel that in defining the morality, defining what constitutional morality is, the court has only used a new label to describe what the court has already been doing for the past 70 years. It's like old wine in a new bottle, right? You're only expounding the philosophies present in Article 14, 19, and 21 and attaching a new label to it. So for this reason, it must surprise a lot of us that the word that in popular imagination, if you read newspapers and if you read columns by legal experts, if you look at all the chatter around the Navtej Johar judgment, immediately following it, you will notice that this term has been highlighted a lot, right? And for a term that has gained salience following the judgment, it appears to be a little vague. And this is where, Pratap Bhanu Mehta has done a very good job of explaining how constitutional morality is actually not as vague as it appears to be, because Mehta claims that constitutional morality is not an adherence to the philosophy, only a philosophy of the Constitution. It is an adherence to the form of the Constitution as well. It is an adherence to the institutions of a Constitution. It is a respect for the institutions of a Constitution, right? So in this sense, when we speak, what Mehta claims is constitutional morality is not about substance, is as much about, constitutional morality is as much about process and form as it is about substance and result, right? So this is one, I think, shortcoming in the Navtej Singh Johar judgment, which in the discussion, in the popular discussion of the Navtej Singh Johar judgment, that needs to be addressed. And apart from the Navtej Johar judgment, there is the right to privacy judgment, which I've been wanting to cover at great length, but I think we're just a little short of time. So in essence, what the court did in the Puttaswamy judgment while describing to us what the right to privacy was exactly this, that it claimed that the right to privacy follows from Article 21, right? And the right to privacy follows from Article 21 because the concept of individual dignity is inherent within the concept of the right to life and personal liberty, right? You are only allowed to, you can only have privacy if you have dignity, and you can only have dignity if you have liberty. So privacy, dignity, and liberty are all concepts that are linked to and flow from each other, right? So this, in essence, was the court's ruling in the Puttaswamy judgment on the right to privacy. What is notable about this judgment is that for the first time, the court clearly claims that the right to privacy is a fundamental right within the meaning of Article 21 in Part 3, right? It settles, prior to the Puttaswamy judgment, the question of whether the right to privacy was a fundamental right was actually up for grabs, and there were judgments claiming the same, but the bench strength wasn't adequate. But the Puttaswamy bench settled it once and for all, and it did so in its articulation of liberty, dignity, and privacy. It was able to do this, mind you, it was able to do this only because of the earlier articulation in Maneka Gandhi, right? Maneka Gandhi's expansion Maneka Gandhi's expansion of the right to life under Article 21 all those years ago in the 1970s, right? Following the emergency, whatever the court did in Maneka Gandhi paved the way for the court's rulings in the Navtej Johar judgment and the Puttaswamy judgment as well. Had the court been conservative in its understanding of the constitution, in its interpretation of the text of the constitution, like it had for the first 25 years before the political regime messed with the constitution, then we might not have had the kind of constitution and the kind of liberal interpretation and the liberal philosophy emanating from a constitution that we have today, right? I would ideally have liked to cover the device of public interest litigation and how it is, the popular perception of PIL is actually not the correct one, but I'm afraid that we are running out of time, and I guess we'll
Perhaps we could have it as a question. Perhaps, yes,
we will take questions now.
Yeah. The floor is open to questions. If there are any, there is already one
Urvi
question.
has asked me second point in the Navjot case. Can you please, what second point? With which point are you referring to? Are you referring to constitutional morality or the relationship between the various rights? Or is it Article 14, intelligible differentia?
I think it's the correlation of the fundamental rights. That are you confused with that, Urvi? No, I think there's. I think perhaps we could keep it for later.
Right.
Siddharth would like to ask a question.
Yeah.
Please go ahead, Siddharth.
Yeah.
Yes, ma'am. Good morning, sir. I just wanted to ask you, it's a bit off the topic, but in the sense that the cases in the courts and all around the country, be it Supreme Court, High Court, or the district metropolitan courts, or the smaller courts, we have around, I think, lakhs of cases in backlog. And this is truly undermining the efficiency of how the court system works. So how do you think that we can, address this issue and, move forward and address all these cases as well, so as to improve the efficiency of the courts and bring justice to the people?
I think one would be to probably create, for instance, there are specific provisions in the Constitution which have sort of created this backlog. For instance, there's Article 136, which has created this backlog in the Constitution. So what we need to do is to create specialized courts to address very specific kinds of constitutional matters, right? And we also need we also need to be more stringent with the kind of matters that are admitted. For instance, you have the PIL, like I claimed, was initially it was brought into existence as something that was supposed to serve the public, but it's very rampantly misused, right? And I feel that not enough has been done to sort of address this misuse effectively. So I guess imposing sanctions as well as creating specialized courts to address each of these matters would probably help. And of course, on that is what we can do on the judicial side, and I think on the administrative side, I think we are really running short of stuff. Not in the constitutional courts, obviously, but in the lower judiciary, I really think we are short of stuff, and we need to, I think, make the appointment process more effective. And this I speak not only from a perspective as a law teacher, but also from a personal perspective, because I've seen some of my friends getting appointed to the lower judiciary a few years after they actually clear the exam. So I think it boils down to administrative urgency in that sense.
Thank you, sir.
Also, I think there are some scholars I'd actually recommend to you later. You could probably write me an email, and I'd strongly recommend. There's a lot of scholarship on how the backlog has made the functioning of our judiciary ineffective. In fact, there's this scholar from Harvard Law School, Nick Robinson, right, who has worked a lot on the backlog of cases in constitutional courts as well as the lower judiciary, I believe. If you could look his papers up, it would probably help you understand just how elaborate our mess is. Nick Robinson, that's his name, right, from Harvard Law School.
Got it, sir.
And it's, yeah, our Indian, he has worked very extensive. He has been working for a decade on the backlog of cases in the Indian judiciary.
Nick Robinson, is it?
Yeah, Nick Robinson.
Nick Robinson. Oh.
You will find his papers on open access sources also, SSRN. I think you will find it on SSRN.
Okay.
And he probably has also written a couple of books on the
Great.
Supreme Court too. Yeah.
Yeah, thank you. So, I think, are there any other questions? Urvi, you can refer to the recording. Okay.
No, ma'am, I have another question too.
Okay. Please go ahead. And we have, Urvi, can you just wait up? We have our vice principal over here, Tessie ma'am, who has a question.
Yes.
Okay, ma'am.
Yeah, just 2 minutes. Yeah. Ma'am? Tessie ma'am?
Hello. Yeah,
Yes,
really enjoyed listening to the lecture. There was so much packed in such a little time. Just wanted to know your view regarding, like, for example, the Koregaon Bhima case and the golden triangle of rights that you've been talking about, freedom of speech, activism. How is it that they don't have recourse to the law and they're still languishing in jail? I just want your point of view on that.
I think the answer to this question, to be very honest, ma'am, it would be more of a political than a judicial answer, because I believe it's the current disposition, and it's my personal opinion alone. I'm not making any broader sweeping statement here. I personally feel that the Bhima Koregaon case is more representative of the sociology of law rather than the law itself, in the sense that when popular perceptions are created about certain kinds of activists and people, it becomes difficult for the court to rule against those perceptions, right? Even when rights are available. So I think judges at the end of the day are human beings, and that's one reason I feel that they have not been having proper recourse to the law. And the other, I believe, is that there are a number of legal regimes that have been brought into existence by the government of the day that are sort of conducive to the abuse of power. For instance, you have the UAPA, right? And so I believe it creates a sort of legal culture where it's possible for the government to keep doing this routinely and get away with it. But that again, it's a very subjective sort of assessment, and it's always up for political debate.
Thank you so much.
Thank you. Urvi, you can have.
Yes.
We have Urvi and Surakshita's question, which has been typed.
Urvi?
Sir, you talked about the traditional approach that was being implemented in the first 25 years.
Yeah.
Sir, the present rulings that I have been keeping an eye out for, do you think that we are adding new labels, but still there is this traditional approach still going on, conservative approach?
No, I think we have moved on. After the emergency, we have made a very definite break with our conservative, textually speaking, in terms of textual interpretation, not philosophical leanings. In terms of textual interpretation, we made a very clear break with our conservative past in the post-emergency years, in the sense that, see, what you must understand here is that the Supreme Court has a lot at stake, right? It is easy for us to claim that the Supreme Court has been an activist court, okay? And that is why it is doing this. But what I personally feel is that the Supreme Court is only doing this because the the memories of the emergency years are still fresh, and they have scarred its reputation beyond belief, right? And it's essentially they are still in damage control mode when they interpret the constitution as liberally as possible, and they will continue doing this for the same exact reason, not necessarily because they care, right? And this is again my personal opinion, but because they will want to exercise the ghosts of the past.
So what do you mean by damage control post? Like that?
See, during there were rights were violated during the emergency years, right? The judiciary was seen as an institution that could be easily politically manipulated, and that's what Indira Gandhi did. And the court also ruled in her favor, right? In, for instance, if you take the ADM Jabalpur versus Shivakant Shukla case, it is known as the blank day for the Indian judiciary. So it is seen as an institution that was emasculated, that did not function with the kind of independence that it was supposed to, right? It was seen as its reaction to the emergency was seen as spineless, okay? And now it wants to change that. It wants to be seen as an institution that has a spine, right? So in other words, it wants to be seen as an activist institution. But I think in some instances, it has gone overboard with the PIL, for example. It has done more harm than good there.
Yes, sir.
The last question I think we'll take is of Surakshita, and I think there is some kind of understanding. Perhaps we could, Shri, can you take a call on this? Why did they have to fight for their...
No.
Yeah.
Yes. Which question, by Aishwarya or?
No. Actually, Aishwarya is just writing down because we have started another meeting. So there are your entire screen has been shared in that particular meeting because we exceeded our limit of participants.
Right.
So there is a question by Surakshita. So I mean, it's written as it's written by Aishwarya.
So the one on the LGBT is
Yeah.
No. See, it's actually they had to fight for their rights because the kind of morality that has been embedded in our culture, and it is actually very strange for you to know that the kind of morality that was at work in the criminalization of homosexuality, it is in popular perception. We believe that it was Indian morality and Indian culture that was keeping the LGBT community from exercising their rights freely, right? While there is certain, I mean, well, obviously we are still very conservative in that regard. Our morality is actually one that is borrowed. It is borrowed from Victorian morality. So it was not only a question of reproduction. I mean, in fact, when you speak of reproduction and the LGBT community not being able to procreate, this sex which does not result in procreation was stigmatized by the British, right? It is a very particular form of Christian morality that was over time, over the years, internalized by Indians, right? So it is not something that was inherent in our culture. It's something that came to us. This sort of Victorian Christian morality came to us with British rule. And this is very thoroughly exposed in one of, there's a scholar called Martha Nussbaum. You can take this down. She has written a very, very interesting paper on the relationship between disgust as a psychological phenomenon and the criminalization of homosexuality. So she has sort of tried to correlate psychology with law, and in the process of correlating the whole thought process of disgust and correlating it to law, she has exposed Victorian morality for what it is. right? So you're right in a sense that it's one of the reasons that they are stigmatized is because their act does not result in procreation or reproduction. But that stigmatization is not inherent to us Indians. It is borrowed. It is Victorian. It is Christian. Okay?
I think we have come to an end, and I think it was a wonderful, very interesting session, Rahul.
Thank
And
you.
70 years of Indian Constitution and just an hour or so to understand this same is absolutely less. But I'm truly grateful for actually highlighting the technical understanding of the Constitution and giving a detailed analysis of all the judgments that were spoken about, and also touching upon more important points such as constitutional values, constitutional morality, which of late has been in quite gusto, which has been spoken all over. So, and I would also like to take an opportunity that, I think it gives me a great deal of pleasure in seeing a growth of a student right from, I still remember Rahul actually presenting on Armed Forces Special Powers Act very passionately in the class, and then moving on to achieving, several, and I do hope I can, the next time I call you, I do hope I can call you Dr. Shri Rahul.
Hopefully, and it's a
Yes.
privilege learning under you, and I will always continue to be your student. That's never going to change.
No. I hope you go way, way beyond that and teach a lot of good things to us. And I thank you sincerely. I thank all the students of this college and faculty members for making your presence felt in this particular forum. And I thank students of other college and faculty members of other college as well. I sincerely thank Mansi ma'am and Aishwarya ma'am for helping me out with the technical glitches, for actually starting another meeting, for being, and there are still students who are joining in, by the way. We have exceeded more than 126 students, Rahul. So that's been
Right.
one of the great, so it's been a wonderful session, and I thank you all. And truly, we have celebrated Constitution Day by really going through the entire journey of what has been. And thank you. And we would like to continue we would like to have you associated with us and continue this kind of session and have whatever topics that you think need to be spoken for.
My
We are
pleasure.
most-
My pleasure.
Yeah. Thank you so much.
Thank
Thank
you.
you.
Madam.
Thank you, all of you. And that's it for today. Thank you.
Thank you.
Thank you, sir.
So I will be pasting, there is a feedback form which I would like all of you to really kindly fill in. So I am just adding it in the text box over here, and kindly fill in the details of the same. Thank you. And hopefully you will be attending the next session as well, which will be sometime later. Thank you.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you.